Welcome. We are so happy to have you here with us today. NAPAA has started a new webinar series. And so just one piece of housekeeping, if you have a neat name at the end of this that you want to throw out there, you just put it in the chat or put it in Q&A. And Nancy is back behind the scenes there, and she is going to take in all of our questions, as well as just chat ideas, things that we ask you for today. Also, as we get going into the topic, if you have a topic that you would like for NAPAA to consider for future webinars, then please share those with us too, because we're going to be looking at some different topics to be addressing. So we want to welcome you today. Hope you have a piece of paper and a pen. We're going to have some hard-hitting topics today concerning E&O and some good information. So I think you need to get ready to write that down. This is very casual. We're friends here, and we just want to make this easy and smooth for you so that you can learn different things. There may be things you're already doing in your agency, but maybe you just get an extra little bit of a tweak or a little help on the topic today of, well, E&O, which is what we're covering, to add to your repertoire to protect yourself and your agency. So I'm Lezlee Liljenberg. I was an Allstate agent for 17 years, and I did sell my agency in 2021. I still sit on the board of NAPAA as executive vice president, which I am very thrilled to still do. I love it. A lot of people ask me why, and all I can really say is that we enjoy helping our insurance colleagues, and mainly within the Allstate realm. So that's why we keep doing it. My life now is as an insurance expert witness, and that is one of the main reasons that I continue to be passionate about educating and advocating toward the knowledge that I feel like agents need to get and prepare themselves, just really so you don't get sued for an E&O claim and you don't end up in a court of law. So joining me today is Dirk Beamer. He is our NAPAA legal counsel. And so Dirk, I know everybody, a lot of people know you already, know your name, but if you'll just take a second, introduce yourself and let us know kind of your background with NAPAA and Allstate.
Sure. Thank you, Lezlee. Very happy to be here today and to see so many familiar names and faces popping up in the Zoom. So, yeah, I've been fortunate to work with NAPAA since 1999. Some of you, if you've been around a long time, may remember that's when Allstate announced the mandatory conversion of all employee agents to independent contractor status. And I was involved in NAPAA in trying to digest and understand that and see what the association might do in response to member concerns. Since then, I've been privileged to work with the association really continuously ever since on a variety of matters, and in the process to get to work with literally hundreds and hundreds of agents, agency owners, done a lot of work with people buying and selling books of business, worked with people on their internal employment practices, worked with people with disciplinary issues with Allstate. For about the past 12 years, I've also served in a similar function with the United Farmers Agents Association, or UFA. So got a pretty good understanding of what you folks do every day and appreciation for how hard it is, and anything I can do to help, I'm happy to share.
Yep. Well, thank you. Thanks, Dirk. You do so much for us, and we appreciate you. But so our goal today is to share some thoughts and information to help our Allstate friends manage their businesses better, and to prevent those E&O claims. And we're going to delve a little bit deeper into the CalSurance policy because it's so important that we understand those coverages, whether we're going to be staying with Allstate or if we have any plans to leave Allstate in the future. So Dirk, as you and I were planning for this get together, you and I talked about you're sharing the definition of errors and omission E&O insurance, because I think there's really a gap in understanding. We pay for this insurance, we kind of get it, but what does it really mean to us as an agent in that protection? So will you share the definition of that with us?
Sure, Lezlee, and it's a great question. And it may seem obvious, but if you haven't thought about it, maybe it's not obvious. But E&O is errors and omissions coverage. It is a form of professional liability insurance designed to protect both agency owners and their employees from claims from their customers, from policyholders, that there's been some form of negligence in the process of delivering insurance products. In my world as a lawyer, or from a doctor's world, it's really the equivalent of malpractice insurance. So it's there to cover both, ideally, and in the case of the CalSurance policy, it's in fact the case, to cover both any actual damages that an agency owner might face for a claim if they are found to have been negligent and have to pay damages, or if they settle a claim to resolve, a lawsuit and have to pay something in the settlement. That coverage, so long as you're within your policy limits, that's part of what you're getting from your E&O coverage. But really equally important, maybe more important, is you're also getting legal defense coverage, so that the insurer is paying to put in place a lawyer who's well skilled in defending E&O claims, and that cost is going to be picked up. So you might say, I didn't do anything wrong, I'm really run a strong practice, so what's the worry? Well, the worry is you could be sued and you could win the lawsuit because in fact you did nothing wrong, but you're $50, $60, $75, $100,000 in the hole because lawsuits are expensive. So having that coverage is really important.
Yeah, I agree. And thanks for that definition, because one, I think the legal counsel is very important. And what I think one of the most interesting things I've discovered in this, after leaving Allstate and, just realizing that, we need this stuff. And when people, really, when agents are being sued, that's where the lawyers are going for first. I mean, they're going after that, insurance being there. So, anyway, so I think one of the most interesting things in leaving Allstate too is the minimum effort required in an insurance agent, of an agent in almost every state. And it's in the legal world, they actually call us order takers, which I found that crazy. I'd never even thought of myself as being an order taker, because I prided myself so much in everything that I did with my customers and training my staff. And so that drives me crazy. It drives me insane that we're called order takers. But with that vein of thought, Dirk, what do you think about that? And what should agents do differently in perceiving themselves differently with this flippant attitude that we're dealing with law? Because we know that consumers want a lot more than just an order taker to help them.
Yeah, I mean, so the good news, right, is historically and in the case law that's evolved over time, the standard is fairly favorable for the agent, and the expectations really are not as onerous as you might think. But I suspect that if you were to poll the general population in terms of what their assumptions are or their expectations of what they're getting from their agent or what they should be getting from their agent, you'd find that they're expecting a lot more than merely saying, hey, you told me what you wanted to cover and I wrote that policy for you.
Right.
I think that they're going to say, I expected you to tell me what I needed, why I needed it, to explore different options, to explain to me why I should be thinking of other options. And I think that expectation is only going to become greater as agents are now competing with, call centers and direct writers. And, if I'm a customer, I can say, if that's what I wanted, just to drop an order, I could have done that online. I chose to work with an agent because I had the expectation that I'm going to get this higher level of expertise and professionalism. So the bottom line is, while the law may be helpful to you, so long as the consumer's expectations are higher, you can anticipate there's going to be E&O claims, because when that consumer finds themselves with a loss, they're going to look for someone to blame, and they're going to rightly or wrongly feel like, well, that was your job to make sure I had the right coverage. So
Right.
it is a real disconnect between maybe what the law says you have to do and what your best practices need to be if you want to minimize E&O claims.
Right. Yeah. That best practices, standard of care. That's what we see so much in the law, in these legal suits, is what did the agent do? And I want to throw in this, I got to know it wasn't part of our original talk, but what I wanted to throw in was one of the things that I see is that, like you said, that gap between what a consumer thinks and then what is happening. But the other thing is being very, very careful. I know we have all state guidelines, but be very careful what you're putting out on those web pages that are not all state compliance, because one of the things that I'm seeing a lot is these websites that say we can service all of your policies. We are the go-to. We are a one-stop shop. I'm going to advise, if you have a website that is saying stuff like that, you need to change the verbiage right now, because it is exactly the verbiage that the counsel is going to be looking for. And that's what I look for. I'm looking for, how did that agent present themselves out in the marketplace? Because that's how you sold yourself to that consumer, was all these wonderful things that you can provide. So be sure, if you're promising that you're doing it. So it was kind of my extra 2 cents worth. So mainly what we're saying is Dirk, if I hear you right, is just because the law is not as strict on the agents, we still need to, we need to be cognizant of what those things might be looking like from a consumer standpoint. So what would be some of your recommendations, Dirk, to prevent, we kind of talked about watch websites, but what are some of the other areas where an agent can do some very simplistic things to prevent their E&O somebody coming after it?
Sure. So, one area, Lezlee, that I think is very important, and certainly in E&O, but even beyond E&O, is just education, right? Making sure that you're finding time. We're all busy. We all think we're too busy to do it, but finding time to make sure you're staying educated in the industry, in trends in the industry, in coverages, and that your employees are likewise, getting that education, because that does 2 things, right? One is it makes it more likely you're going to do the right things to avoid ever facing a claim. But if you do find yourself facing a claim, you can point to that and say, look, no, I'm not some Joe Schmo here. I am a very experienced, qualified agent. I've done all these trainings, all these classes. So when I tell you that my practices are good and solid and it's not my mistake, my track record would tend to lend credibility to that. And the jury or a judge is going to say, yeah, that person seems to know their stuff. And they've demonstrated that by trying to stay on top of the industry.
Right. I always just say that the documentation, I mean, I want to throw in right there too, is don't depend on, I guess, e-agent. We're still using e-agent, right, Ted? Was that?
Well, now
we're still using e-agent.
Yep,
so,
yes, they do.
Because, I know our platforms change, but documenting, like you said, Dirk, those procedures being in place, documenting what you do, because just because you sit down and say, oh, well, all my agents do exactly X, Y, and Z. And I remember when I first got into the business, and it was Laura Harris, she's still around. Laura Harris taught a class, and it was about the processes and procedures and documenting. And I cannot tell you how many times I didn't have a lot of issues. I probably have 3 different issues while in those 17 years that, man, I had that stuff in e-agent, but I also had it in other areas. And I had all those processes and procedures in writing, in notebooks, and every single one of my staff had them sitting at their desk. And those were the processes. And those were the things I was able to say, this newsletter went out, this happened, the customer got this information, this happened. And it was so nice to be able, what a peace of mind that we had in the agency to know that stuff was in place for us to protect us. And it's I guess I would really say, don't be lazy, just do it. It's not that hard to do.
Yeah.
And we do have a question out there that I get quite often about S corps, what C corps, and once you dissolve them, does that relieve the agent of any kind of E&O exposure? I don't personally think it does.
No,
but Dirk, you might want.
Yeah, no, it does not. No, so incorporation and maintaining your corporate status is important, and certainly provides protection from certain liabilities that are in the name of the company, not the individual. But by its nature, professional liability rests with an individual, right?
Right.
That's the essence of it, is you are a professional, you personally have some degree of training, expertise, etc. And so you're going to be on the hook, you or your employee, whoever it is who allegedly did the wrong thing or failed to do the right thing. So, and I would say, frankly, keep the entity in place longer. It won't solve the problem, but people who think that I want to dissolve my entity quickly, that's bad. That's a bad practice.
Yeah, we want to get out so fast. You know, we want to disconnect so quickly, and we're either excited about our next step, or just maybe it is getting out, whatever it might be, or you're going to do something else. I mean, that you're still there, you're still on the hook, and we're going to cover, we're going to touch base on that here in just a second, about those coverages we want you to be looking at on that CalSurance policy. But Dirk, I'm sorry, I might not have been listening as well as I should. Did you cover the employee handbook?
I did. I want to, but before I do that, I just want to say one more thing about, in general, documentation. It helps you with an E&O. It also will help you, by the way, if there's any kind of investigation that Allstate is conducting in terms of your practices.
Yes.
You will be far better positioned to deal with that, and far more likely to have a favorable outcome if you can demonstrate to them, hey, I'm on top of this. If there was a mistake made, it wasn't for lack of effort or supervision or planning on my part as the agency owner. So it's a lot of benefits from doing it the right way. So that just ties into employee handbooks, which are a very important tool to demonstrate that you, not only are you training your staff, but you are holding them accountable, and you're setting out the expectations, and you can point to, here's how we deal with things. If I have a disciplinary issue, for example, the rules are clear, they're in place. That will help you in an E&O setting. It'll help minimize the chance you get to an E&O setting, because your staff knows you're holding them to a certain expectation. And again, it also will help you if you find yourself in a dispute with an employee or facing an employee claim. Your employee claim is not going to be covered by your E&O. You have the option of adding EPL, employment practices liability coverage, at an additional expense, but that is not going to be covered under your basic E&O policy. So you want to maintain best practices to minimize the likelihood you get sued by a disgruntled current or former employee.
Yeah, because they're just two separate birds. They're two different types of policies. And I mean, that's when I am working on a court case with an attorney, those what we just went through, what you went through, Dirk, are exactly what I always ask. I want to know what that agent's processes and procedures are. You know, what do they have an employee handbook? And you know, how do they define their day? And so that's what we're looking for in order to want, you know, one, if I'm on the side that we're going after the agent, I'm asking that, but I'm also, if I'm trying to help that agent stay out of trouble, I'm asking those same questions. So it works from both sides. So I think that's really important. And I truly am amazed when I'm doing different classes or talking to people, how many people do not have an employee handbook. If you don't have one, those are very easy to put together. And I recommend you update it every year. We have so many things that change, like COVID, like tattoos, like, I mean, all the things that you don't think about if you're not thinking about them.
Hair is a legally protected status now, most places. How your employee chooses to wear their hair extends protections to them that you may not understand, because it's new.
Right. And so so whatever those might be, I mean, you know, some of them you can't legally put in that employee handbook, right? You do need to understand the law. You need to understand employee laws a little bit, so that you aren't putting something in your handbook that you're going to get in trouble for later on. But they're simple to do. It's a good ground level foundation for you. Like Dirk said, either in an employee situation, but also you're showing due diligence if you ever get into a situation where you've got an E&O case in front of you. So with all that said, we know there are these great things that we need to be doing in the agency. You guys, you can bite off a little bit of this at a time, but these are not difficult things. If you're doing them already, I recommend you review them if you haven't in a while. And if you're not doing this stuff, is take some time to put it together. Okay, so here's my embarrassment moment. I have to admit, I never read my E&O policy the entire time I was at Allstate. And and so leaving Allstate, my aha moment was when our executive director of NAPAA, Ted Paris, when he started sharing what the CalSurance policy would cover and what it would not cover. Wow, did I have an eye-opening moment that I did not take that time to really look at that policy before I made my exit. Well, even during the time I was there all that time, that when I was taking my exit, that I did not take that time to look at those coverages in that 1 year, 2 year, I think Ted said 3 year, 5 year, and lifetime. So all these things. So Dirk, what our agents need to be doing to protect themselves moving forward as they look at their CalSurance policy?
Yeah, great question. So let's just talk for a minute about what those coverages are going to be after you leave Allstate. If you retire, you go independent, whatever. The base tail coverage on your CalSurance policy is 1 year. So if you simply say you get 90-day notice of termination, you ride that out, you take your termination payment, you're going to have 1 year of coverage. That can be extended at your option, and those are the different coverages Lezlee referenced, for a 2-year period, a 3-year period, a 5-year period, or basically lifetime coverage. Those are additions that you have to choose at the time that you're terminating, and you obviously have to pay for that enhanced coverage. I want to clarify the 1 year automatic coverage. That will be shortened to 90 days if either you choose to say, hey, CalSurance, I'm no longer an agent, so I want a refund of my policy. You can do that, but in doing that, you are shortening your coverage to 90 days. The other way it gets shortened to 90 days is if you sell your book. If you actively have a buyer, you sell it, now you're going to be limited to that 90 days as well. So you really need to be sensitive there to how short a window of coverage you have and the likelihood that you should be buying one of these extended periods. I'm always a little bit shocked, to be honest. Agents want to talk about tail coverage and they want me to tell them that they don't really need it or they should get the shortest, cheapest available. And I laugh and I say, you've made your whole livelihood selling risk protection, but you don't seem to be taking your own advice. So you need to analyze your circumstances and think about what it's worth to you and what the risks you face are. I'm dealing right now with a situation where an agent exited, took TPP. The book was placed with another agent, and now the original agent is hearing from his former customers how the new agent is bad-mouthing him. Now, everything that comes up, that was wrong, that was bad, that was their fault, they gave you the wrong advice.
Yikes.
So think about that. If that's, the new agent doesn't want to look bad, maybe it's an opportunity for the new agent to try to upsell or whatever, but they're feeding that information to your former policyholders. So that just increases the risk. Someone's going to try to blame you when there's a problem. You're no longer with Allstate if you have tail coverage, right? By definition, if you're on a tail policy, you're not with Allstate. What's Allstate's motivation to resolve a claim and pay out a claim, or to try to shift that to you if you're no longer an agent, right? It's kind of common sense. So there's all sorts of reasons you need to think about why it may be in your best interest to extend your coverage. The bigger your book, the more risk you have. The more complex your coverage is, the more commercial business you did, all sorts of reasons you might think about extending that coverage. And likewise, why you might think about not having the minimum, which is, I believe, $1 million, right? Claim.
We're going to talk about, limitations there. Yes.
Right. So, so think about whether you're walking away from Allstate, what's it worth to you to know that you're done? Whatever comes up, worst thing that happens is you've got coverage. you've got a carrier, they're going to provide a lawyer, they'll deal with it. Things to think about.
And the other part about it is, for me to interrupt, sorry, is Dirk mentioned it, but if you sell your book to somebody else, there's a certain expectations of the clients that the new agent is now responsible for your book. He or she's had 3 or 4 times to review the policy versus taking TPP. My claim is if you're taking TPP, you need to have a better E&O policy than if you sell.
Absolutely.
Yeah.
I agree, Ted, because I mean, that's the, and Dirk, I totally agree with you. I mean, that's what you see is there's so many times where you see the agents kind of at the end, we'll use the word tail, at the tail end of all the pieces of a lawsuit. And they're kind of the last man standing, and maybe things are being settled out. Maybe things are happening, but that agent is still there and they're on the hook. And I mean, I remember, this isn't after the fact. I wish that I had known this. And even Ted reminds me, this was probably in my exit package when I left Allstate. What did we say earlier? You're so ready to get out of there. You're not thinking about it. And you're just ready, and you don't even think about that. And so that's why we're here. We're trying to get you to think about it, because these tails and purchasing insurance, you know what, if you're selling you're selling your agency for $1 million, what's another 2,000 out of your pocket, or 3 or 4 to take care of yourself? It's well worth the money to do that. And so, I think it's all good information. And Dirk, you brought up the limits already. And like I said, I know I was carrying 2 million at the end. So we're not saying exit Allstate. That's not what we're saying. NAPAA never, that's not our goal and plan here. We're just saying, if you're staying, you may want to even consider raising your limits. It's really not that much more money. Because the truth of the matter is you are still at the day's end responsible for those people that are working in your agency as well. Mm-hmm. And Dirk, there was actually something we figured out on that policy about employees. I think we were talking about it.
So the good news is, right, the policy does clearly extend to not only what you do, but what your employees do, right? And and consider that's as it should be, right? Because ultimately it's your agency and you're insuring the business of your agency. But consider, if an employee makes a mistake, you can be darn sure that the injured consumer, that the lawyer for the injured consumer is not going to be satisfied just suing your employee. They're going to say, hey, it says that the Charles Jones agency on the door. I'm coming after Charles Jones, coming after him individually, coming after the agency, coming after the employee, anybody I can get on the hook. And think about that when you're thinking about how long you need to keep tail coverage.
Right.
Imagine there's a new agent, whether you sold to them or they've been assigned the book from Allstate, and there's a claim. Maybe it is the new agent's fault, but if I'm the lawyer for the consumer, if I'm looking at my options, I'm going to sue everybody who potentially has responsibility. And that could mean the agent who has been out for 2 years, 3 years. If there's any conceivable way that this alleged mistake can be tied back to what that agent did, you're going to get named in the lawsuit.
You're going to do it.
Limitations for negligence in most states is 3 years, right?
Right.
That's what E&O is about. It's about negligence.
Yep.
So you say, well, I'm just going to stick with the 1 year. All right. But understand that by law, and again, I'm saying in most states, any given state, it might be 4 years, might be 2 years, but 3 is pretty common. So that means you let your coverage run after a year, but it's 2 years, problem surfaces, you are fully legally at risk for that claim.
Right. Well, and that's really good to know, because that 3-year time frame is not, a lot of us don't think about that. And also, and just tapping on employees. I mean, we love our employees. They help us run these businesses, and they're so vital. But be very careful because the fact of the matter is in your training with them, is because you need to make sure that they know how they are supposed to react and act in any given day, because they will be deposed. If you have to go protect yourself, they're going to be the first person deposed. And you want the way you run the business, that the same thing's coming out of their mouth, because, and that they're telling the truth, obviously, because they're under oath. They have to tell the truth. So that's really important. And I know we've got a couple of we covered that, the limitations was really what I wanted you to get really in depth with that, Dirk. And I think that helps. Ted, is there anything else that you really know that?
There's on E&O, you have to understand is that this, and Dirk mentioned this, broached it earlier, is that really you're going to be prepaying legal expenses in case you do get sued. And that's included in the policy. And whether or not you don't want to pay a $5,000 bill, these attorneys are not inexpensive to do. And if you hire your own attorney, they're not part of the E&O policy, so they're being paid extra, and they're not necessarily going to have influence with Fireman's Fund or whoever covers it out there. So just be careful. If you TPP, you're gone. The new guy in Allstate's going to blame you in a heartbeat, without a question. And then if you sell to somebody, they don't want an E&O under them, so they're not going to exactly protect you as well, to protect you. So you need to protect yourself. And Dirk is correct. You made hundreds of thousands or millions of dollars selling insurance, but you don't want to protect yourself when you leave. That just seems a little bit ludicrous to me. We do have another question out there about that Mary asked about when I purchased my book. She supposedly agreed that after 1 year she would assume all liability, and she's wanting to know if that would hold up, and I don't think it would. Dirk, did you see the question?
I didn't, but I understand that you could contractually agree with your buyer that they're basically going to indemnify you and hold you harmless, any claims arising from the book of business, no matter when it originated. So I think that would, if it's done properly, that's enforceable against your buyer, but that's only as good as your buyer's financial ability to stand behind their contractual commitment. That in no way stops the consumer, the customer, from suing you, right? So if you're sued, you've got to deal with it. You can look to your buyer and say, hey, see here where it says in our contract, you're going to indemnify me. Please step in and do that. That's entirely dependent upon their financial wherewithal, and that may not be there. So I would not say I don't need E&O because I'll rely on my buyer covering me. That seems like a risky proposition to me.
It's just like putting a little bit of extra. Right. Well, I was going to say, just put a little extra padding there.
Right.
It's just giving you that extra padding to be careful. I saw a question, Ted. Is that what you're about to touch base?
About the 3-year limit.
Statutes. Right. Yeah. I think Dirk kind of clarified that was not in all states. I'm going to say, Dirk, probably they need to check their state by state.
What's the question exactly?
Is the 3 years good in all states, in all the different states? And does it relieve them after 3 years? If in 39 months they get sued for E&O, does that 3-year state limit them?
So again, first of all, that is not true in all states. Every state in the union has its own set of laws regarding statutes of limitations, number one. Number two, there are different statutes of limitations for different types of legal claims, right? So just here in Michigan where I am, statute of limitations for negligence is 3 years. Statutes of limitations for breach of contract is 6 years. You could have somebody argue, no, I'm not suing you for negligence. I'm suing you because we had a contract that you were going to provide services, and here's what you were going to provide me, and you didn't provide me what we agreed to. So whatever the statute of limitations is in your state for a given claim, once it expires, it should protect you against those claims. But it's a very complicated area of the law. It's very nuanced. And again, it's specific by state and by type of legal claim. So if you want to really dig into that and make your decisions based on that, you should talk to a local attorney in conjunction with deciding how long you're going to keep your coverage.
And I've had a couple of questions from existing agents the agents who have left, and now they're buying, starting a IA up, and they're wanting to know whether or not their new E&O with the new entity is going to protect them against against E&O claims at Allstate. And my comment is, you need to read what the retroactive date is. And can you explain the retroactive date to agents if they're going to leave and not try to buy a policy with CalSurance?
Yeah, so that's a great question. And that's something you really need to, dive into, is understanding exactly what period of time is covered and what activity is covered, right? So your CalSurance policy, for example, will cover you, as I understand it, back to your inception with Allstate for selling Allstate products or outside business that's approved by Allstate.
Right. It has to be all
Right?
under the Allstate world. Yes.
It won't cover you for anything else you might have done that's not within that Allstate umbrella, for example. That retroactive date, so let's assume you leave Allstate, you leave CalSurance, you buy a new policy. They're going to similarly have date at which coverage begins or retroactively begins and terminates. And that depends on the policy. And in fact, you probably have different options under the policy, depending on what you choose. But you really need to understand under your policy, when does coverage begin and what is covered, right? And again, obviously you've got, is it a claims made policy? All the questions that you always have when deciding, what is getting covered with this product.
Right. Is it claims made or occurrence made? And,
Right.
that's a little bit more in depth, and it's not a lot of people know what the differences are. I think I still have to look it up every time I'm trying to work on something, but, do we have another question, Ted? I saw something pop up about requiring the buyer to review the policies or something.
Yeah, there was one there, whether or not that would be enforceable. The problem about and then Dirk can take in it, but the problem is you can be sued for anything. And even though you have a side agreement with someone, is that going to hold up in a court of law? And even then, if you have the side agreement, who's going to pay your legal defenses while you're fighting this?
Right.
Which would be included under your E&O.
Excuse me, I'm sorry, Ted. I didn't mean to interrupt you. I was going to say on that with the buyer, with the agreement that you've got with that buyer too. I mean, you can't, that's a hard thing to hold their feet to the fire. My recommendation would be, if you're going to do that, is even make an agreement. This is what I would do. And I did do it. I stayed in the agency for a month and a half. And that was part of my contract. I stayed in a month. I wasn't sitting in there every day, but I was there for a month and a half to be a consultant to them. And I helped them. And with doing that, I helped them review policies. If you're going to hold their feet to the fire and it's going to be in your agreement about reviewing the policies, I would recommend you be a part of that. And then you're going to come back and be able to say, we reviewed these policies together, and there shouldn't be a reason why this has fallen through the cracks. Is it going to prevent it? Like Ted said, anybody, you can get sued for anything. That's just another piece of the padding. And are you willing to take that time and do it? Then
she followed up with the question about what is the responsibility of the company if you're taking TPP. Well, once you're gone from Allstate, you're gone from Allstate. Allstate has no responsibility to protect you.
Zero responsibility to you whatsoever. And they're not going to protect you. I'm not trying to be anti-Allstate, but that's any carrier that you work with. You're absolutely gone. They're not going to protect you. And they're not the only, I work with a lot of different attorneys and carriers, and it is that Allstate is not any different than anybody else. That is just the way of the insurance world. And I see cases that they're active agents with that carrier, and it's still kind of a free for all, and you're kind of on your own. And that's why we wanted to do this webinar, because we don't realize this so many times, and it's very important. I think we have Nancy or Ted. It looks like we've got another chat, and there's another question in the chat. Where are we on time, Nancy?
We're good. We're at 1:45.
Okay.
What responsibility does the company have if taking TPP of reviews, etc.? And then doesn't the company have the same level of adherence to the customers as they have required of the agents? They pushed us for years for annual reviews.
You want me to take that one, Dirk? I think
Sure.
annual reviews goes back to documentation that we started with about midway here. Your annual review is your protection against the consumer saying that you did not do what you were supposed to do. Your two basic responsibilities as an insurance agent in most states, and you look up your own state, what are your duties as an agent? If you never, I had never Googled it. Your main duty is to procure the insurance that you have been asked to procure. And if you cannot procure that, the second thing is you are responsible for telling the consumer you are unable to procure that policy. So that can feed into a lot of different things. That's your job. And Allstate has duties, but if you're the frontline agent, that's your duty. And I mean, Allstate's going to be there for you, but Dirk, you may field it. Ted, you may field it. I just don't see the carrier in most cases protecting you in most situations. They have to adhere to their laws and their regulations, and that's why they're on you about doing that. But remember, most of the regulations that you are having to abide by within Allstate, those are not insurance laws. They have nothing to do with the insurance laws. So Dirk, you may, y'all might have something else to add to that.
Yeah. So I think some of these questions, whether it's, well, what about the buyer? What about Allstate? They all kind of circle around this notion that there's somebody else who contractually or otherwise will be responsible. And what I would say to that is that may or may not be true contractually or legally, but what may not be true is that that's how the world is going to play out, or that there's some sort of contract police out there who are going to just magically appear and say, no, that you really need to bring that claim against Allstate, not against the agent, or hey buyer, you should do the right thing, step up here because you signed this agreement. It's all going to play out because somebody's going to sue somebody else. And your options, if you are sued, are to defend yourself. And if you have a claim against whether it's Allstate or whether it's against your buyer, to say, hey, really isn't my problem, it's your problem. The only way that gets handled is in the courtroom. So again, you can have a piece of paper that says it's their responsibility, but it's only going to get enforced if you take legal action. And the minute you have to take legal action, you've lost.
Right.
You've lost. You can win, but you've lost because it's costing you a lot of money and stress.
Well, and money and stress, and you're trying to run your agency. It breaks my heart what I see agents go through. The stress of trying to run their agency still. There was a really good question that just popped up. It popped up. I didn't see it very, very quickly.
Which one? The one about e-agent? The one about I'll do these two questions here real quick.
Okay.
One that says, since we no longer have access to e-agent after we leave, how do we defend ourselves? Well, that might have to be a subpoena to get the e-agent records in the court of law. And the second one, it says the company asked here about assigned policies of 2% to an agent. What responsibility does the new agent have? The new agent really have no responsibility if they're just assigned agent, other than to collect premiums, review coverages, whatever. If they present a claim against you that you either didn't do something you told them would do, or didn't do something you knew you should have done, then you're going to get sued for E&O. Is that correct, Dirk?
Well, in that case, I mean, the person that's getting the 2% is probably going to be right in the same lawsuit. I mean, you're both probably going to be mentioned in the E&O and the lawsuit. I mean, neither person's probably going to be completely off the hook. The only thing I have to say about the documentation, you have to leave your files behind. I always still had my hard copy files. You have to be very careful about what you're taking with you. But if you feel, I mean, if I had, in hindsight, if I looked back, I mean, there were probably some things that I might have with a couple of customers that were troublesome. I might have asked Allstate if I could take those notes with me, or have kept that file, or made a copy of it, because it is so difficult when you're going through and you're being subpoenaed, like Ted said. There's so many times this stuff is just gone, and no one will find it. It can't be found for discovery. It's in this law land, and you're kind of stuck. It's very difficult for the agent and even the carrier sometimes. So it may fall on false ears of the person with Allstate. But I think I would put it in writing even. Here's a concern of mine. This person's made a complaint about me, even with TDI. And then if you know about that, then I would ask for special permission. I wouldn't just let it go. I would say, I've got this concern as I'm leaving. And I would like to, in writing, Allstate, I would like to have a copy of this file, or I would like to be able to take my notes. Would you please allow me to do that? And if they say no, keep the note that says no. And, you're leaving, but make sure that you're leaving with appropriate information. I am working on a court case right now like that situation. And it's not an Allstate thing, but it is a situation where the complaint had already been made, and then the files were not kept. And so it really makes the agent hard to defend themselves. It makes it hard for them. So,
and I recommend, if I could just add to that, Ted, I do, getting on what do you do with your buyer if you're selling? I certainly do recommend that in your purchase agreement with your buyer, there's a provision that provides that the buyer will provide you access to documentation as needed post-sale to defend yourself in an E&O claim.
It's really a good point, because I know that the buyer that bought my agency, one of my agencies, actually was in trouble 8 months later, and he had shredded all the files, all of the hard copy files that were there. And then even as the transitions occurred, miraculously, there were notes and things that were gone. That's hindsight. So, we're telling you things, and so that in hindsight, you don't make those same mistakes. So, Ted, did you have another question?
Well, I was going to say, we keep asking a question that I get asked all the time from agents outside of this webinar. What should I buy? Buy 2, 3, 5 lifetime? And I think Dirk broached out earlier today is, well, number one, depends on how large a book you're selling. Number two, is it being TPP'd, or you're selling it to someone else? How much commercial do you have out there? What kind of personal assets that you have and you want to protect? All these things are important. The answer would be is that you want the best possible protection, then you buy the lifetime. Are we going to give you our opinion on which one you want to buy or should buy? The answer is no. You need to consult with your CPA. You need to consult with your attorney. You need to consult with your other advisors about what kind of liability that you want and what kind of protection you want. At $500 an hour, if you buy the lifetime, then you have pre-purchased about 150 hours of attorney time in case you get sued.
Yeah.
So peace of mind.
I would throw out there just some not legal advice, practical advice. Yes, talk to your CPA. Yes, talk to your lawyer. Talk to your spouse if you're married, because that's where this liability is going to come home. You better make sure that they don't find out after the fact. What do you mean? We could have had coverage for this, but you were saving a couple $1,000. So,
because it can put you in a dire situation without
right.
having it. And we're not trying to be like the bad, but it's just, we want you to do the good. And we want you to be protected. So, are we getting close to time, or is
we're getting close to time. And one guy wanted to know about the lifetime protection again. That is the absolutely best you can buy if you want to sleep at night when you're 93 years old. Then that would be what you might want to consider buying.
Yeah. I agree. We've said it. A question was about the S Corp earlier, and that my first thing out of my mouth too would have been that would be a question I would definitely be asking my CPA. But every CPA also has a different opinion. I mean, I had my buildings under an LLC, but I ran the agency under sole proprietorshiip.
Just because you
recommended.
Yeah.
So
just because you form an S corp or you form LLC, you know, everyone thinks you have this shield of protection that they can't get pierced. Well, you get a court of law, they say, well, why did you form an LLC? Well, for tax purposes and protect my liability. The judge is going to go, sorry, that's not going to protect you from professional liability that you have.
Yeah.
At least in my opinion.
No, that's right. Don't misunderstand. I mean, you do need to talk to your professionals. Generally speaking, you should incorporate. There's all sorts of advantages, including protection against various types of liabilities.
Mm-hmm.
But professional negligence is not included in the types that are protected.
Good to know. Yeah, that's good. So
we have 5 minutes, Lezlee. If any last questions, wrap up.
Last questions, we throw them in there real quick. We'll see if we can do that. Thank you, everybody, for being here. If you also have, I mentioned it at the very beginning, if you jumped on a little late, if you have topics that you would like for NAPAA to address, I can't tell you we can give you all sorts of legal advice or anything like that, but we can sure find people that have the background and the knowledge to answer things. I been gone for 2 years. I don't have all the Allstate answers, but we certainly have a lot of really, really intelligent human beings that are part of this organization, not just the board, but as members. And we want your feedback. Hopefully it's positive, but it doesn't always need to be. But we're trying, we're working very hard to bring you guys cutting edge information to make your agencies run better. So share those, and we'll see if we can get to them, and we'll see if we can find somebody that can address them. So Dirk, anything else that you wanted to add? Or
I would just say what I tell people all the time. When they're deciding whether to spend the money to get a contract with a buyer, for example, I say, hey, that contract's just like an insurance policy. In both cases, you're choosing to spend money hoping you never need it.
exactly.
Right? And you're saying, I happily spent money and never got any value out of that product because I never needed it. There was never an issue. The deal went smoothly, or in the case of the policy, I never faced a claim. That's money well spent to find yourself in that situation.
Need a homeowner's policy. You need all the other insurance just as much, even though, like I said, it's there for your protection, just in case. It's for a crisis, not a maintenance.
Yeah.
Ted, any last words of thoughts? Or
no, I'm fine. Someone asked about lifetime coverage. The lifetime coverage is 5 times your last year's premium.
Okay, on the cost.
On the cost.
Yeah, and you guys can call Calsurance. There's a great Q&A out there. Ted, do we have that on the website on that Q&A?
Well, that was that one that I gave you guys. With Allstate posted it in October, and they will post it again when I think the new upping is right now in September, October. Allstate will post on their gateway all about the policy, and they're actually just, so you need to check your gateway to find out what that is.
Okay.
You can go
I would recommend everybody to do that, print it off, have it for yourself, because even just doing this webinar, it was extremely helpful to have that. Dirk, I'm sorry, what were you saying?
No, I was just going to add to that. You go to www.calsurance.com /Allstate agent. You will find the actual policy.
Perfect.
And
Nancy,
again,
can we add that up when we do throw the rest of information, or put it up somewhere, or add that? Great.
Yeah.
Well, again, thanks everyone for joining us. Spread the word. Tell your other fellow agents that we're providing some really great information, and we love. We want every Allstate agent to be a member, every retired Allstate agent to be a member, and anybody that wants to keep in the loop. So thanks. Have a great rest of the week, and hope everyone is having cooler temperatures, and the consumers are cooling down too. And happy selling. And we at NAPAA wish you all the very best on every single day. Thank you.